It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. Welcome back to FLA Law, live on the radio. Thank you for joining us. My name is Jacqueline Bryant, and I'm here with my co-host, Lorraine Robinson. And hopefully you've been tuning in every Tuesday at 5 o'clock. But if not, welcome to FLA Law, live on the radio, which is your live legal call-in talk show. And as our intro says, we are the personal injury attorneys of Perenich, Caulfield, Avril, and Noyes. And we are glad to come to you every Tuesday, answering your legal questions live here on the air, and of course, discussing various legal topics with you every Tuesday at 5. So if you find legal shows interesting, you have legal questions, or you have family members and friends who are interested in the law, then this is the show for you. Call up a friend, let them know that FLA Law is live on the radio here at WTAN. I also want to, of course, give you all the information and ways that you can continue listening. If you step away from your radio or you want to watch us live in the studio, you can do that also on our streaming platforms. Right now, we are streaming live on Facebook and on YouTube. So if you would like to see us in the studio, Lori and I are here and we are ready and willing to answer your phone calls. And Facebook, you can find us at Perenich, Caulfield, Avril, and Noyes Injury Lawyers. That's how you'll find our live stream. I'm actually going to go ahead and share it out for anybody that I'm friends with on Facebook. That way, if you're looking for it, you'll see it right there. And of course, just type in Perenich, Perenich. You should be able to see the red circle around our firm logo. That shows we are currently live. Just click on that, and then you should see Lori and I in the studio. You can type your questions or comments right there at the bottom in the comment section. If you want to chime in on the discussion this evening, or you have a question for either myself or Lori, feel free to type it in the comment section. And I'll read those out over the air, and Lori and I will attempt to answer those for you or try to point you in the right direction or the legal area that it might apply to. If you don't have a Facebook account, but you do want to watch us live, you can do that on YouTube as well. Same name. It's under Perenich, Caulfield, Avril Noyes Injury Lawyers. Just search that over at YouTube, and you'll find, again, the live feed there as well. And then if you only get to listen to part of the show, but you want to be able to pick it back up later and listen to it again, then you are in luck, because we also have a podcast, and our shows will be uploaded later in the future on the podcast. So you can see past shows, you can see tonight's show, and then of course, moving forward, the shows after that are always going to be uploaded as well. And we are on Spotify, iHeartRadio, and Apple Podcasts. So if you have an iPhone, you can look it up right there on your iPhone under the podcast app, under FLA Law Live on the Radio. Search that, you'll find our podcast. Follow us, and you'll get an update every time a new podcast is uploaded. Hopefully, again, you're tuned in. Share with your family and friends. If you're on Facebook, like, comment, share with everyone. Let them know that FLA Law is live on the radio, and we have our special co-host, who's always a pleasure to have, Lori Robinson. Thank you for joining me tonight.
Always happy to join you.
Thank you, thank you, thank you. And of course, I have to do it. I said I'm going to do it every time I'm here, celebrating our 70th anniversary, strolling down memory lane as we have been. And again, I just think it's something that we are extremely proud of as a law firm, to say that we have been consistently in business for 70 years.
It's a very long time.
Yes, helping people that have been hurt, people that have been injured due to no fault of their own, and just helping them through the process of their injury cases over 7 decades. And so that is an amazing feat. Of course, neither of us have been with the firm for that entire time.
Not quite that time.
But of course, it is something that we certainly, share in the celebration. And you and I both have been with the firm for quite some time now. And so each time I'm on the air, I try to go a little bit down memory lane in different ways and different memories, and jog your brain and try to see what things you might recall. And tonight, I wanted to ask you about anything that you've encountered. Obviously, you had a long career prior to even joining the firm and had, done various areas of law and tried many, many cases even before joining Perenich, Caulfield, Avril Noyes. But you have been here with us for quite some time. And I wonder if there's anything that comes to mind since you've been with the firm that stands out as far as a practice lesson, if you will, or something that a judge has shared, or a piece of advice, or even something you learned from a jury after a trial. And you're like, you know what, after that, I think I'm going to do this a little bit differently, or however you might remember it. Is there anything like that that might stand out to you?
Well, actually, it's something that I've been, my 27th year with the law firm, which is hard to imagine.
By the
there
way.
you go. And I wanted to kind of follow up with what you were saying by saying, the thing that happens, and I know you've been with the firm, is it 13 years?
Yeah.
That's a long time. What we both benefit from the 70 years because of the fact that the firm's practices and the experience and the knowledge have all been passed down to us, and we're beneficiaries, and our clients are beneficiaries of that longstanding experience. So there's so many things that have happened, but one of the things that I immediately came to mind when you posed that question of what stands out, which because over a period of time, it's kind of hard to think, but there was one
you
case.
Have a lot to kind of grab from, I'm sure.
And after a while, it's sort of, probably in life, we realize this thing, and something you'll remember very well in the moment, and then so many things happen and your memory bank is filled with so much that after a while these things fade into the past. But the thing that came to mind anyway with that question was a case that actually Matt and I tried quite a few years ago, and it resulted in a hung jury, and that's a very unusual thing in a civil case. You hear about that in criminal cases.
You do, especially murder trials.
Right, so the jury has to reach a unanimous result. They have to all agree. And in a criminal case, sometimes it'll occur that they can't. There's a holdout.
Especially when the standard is so different with criminal, with beyond a reasonable doubt versus in civil with the preponderance of the evidence. So I could understand how it happens more on the criminal side.
But actually, what I'm going to share, there's a commonality, because one thing that happens, a trial is really, you've got jurors are not professionals, they're not lawyers, they're just, it is our constitutional right under the 7th Amendment for civil cases to have a trial of our peers in a civil matter. And obviously we also have a constitutional right to a jury trial of our peers, but it's a personal thing. And so jurors, being people from all walks of life, they kind of look at things from their own perspective. And one thing that can happen in a criminal case is obviously a person might have sympathy and be a little concerned, about someone going to prison or whatever. Well, the truth is that's the same thing in a civil case. And so, in our particular case, the jury could not reach a result. They deliberated for a very, very long time, and it was an automobile accident case. And we had a very nice client. And when you bring a personal injury action, although insurance is ultimately responsible if the person has insurance that caused the accident,
absolutely,
the jury cannot be told that.
They don't know about it.
They have no idea. And so the defendant in this particular case was an older gentleman, and he actually was a little bit sickly. And what ended up happening, we didn't know, of course, initially what it was the reason, but when the jury could not reach a result, even after the judge instructs them to try really hard, basically, then you have a mistrial. And sometimes the jurors, they don't have to talk to anybody, but they have the right to reach out if they want to. And in this particular case, that did occur. And we learned that you
were happy.
because you're very curious.
You're like, what happened?
You want to know what on earth, and in that particular case, we learned that one juror was simply unwilling to render a verdict against this older gentleman who, seemed kind of frail. And you can, on a human level, totally understand this. I certainly understood it from my criminal defense days, basically. But I had never really encountered it, so I was as aware of it as I was in that case. And so that there's not a lot you can do as a lawyer in that setting to change what you do, but you one thing it certainly sensitized me to in a jury selection process.
Now in voir dire, you're asking that question.
Exactly. And to really dwell on that it's the personal aspect that's involved there. And to be aware that that's always a factor. So, the case did end up having to be retried. We did achieve a successful verdict the next time around, but it was really a lesson that I have not forgotten. You learn from every case, every single case.
Absolutely. You take tidbits from everything. That's for sure.
Right.
And I have to agree with you 100%. I think the last case that I tried with Brian Caulfield, that came out quite a bit, actually. There was one person in the jury pool who was quite adamant that he could not in any way, shape, or form decide the case without knowing about insurance. And then it got other people's hands popping up. Well, I'd want to know too. I kind of want to know about that too. And so I was like, well, good thing you asked that question, or we may not have ever drawn that out if that question hadn't come up.
And trying to get a little discussion, of course, it's a little bit tricky because we as plaintiffs' attorneys understand why people want to know that.
Of course.
And it seems like a piece of information that you should be permitted to know. However, the law is that that can't be told because of the fear that a person would be more willing to render a higher verdict if they thought there was insurance coverage.
Right.
Yeah. And so that's the theory behind that. But it does really create a lot of pressure on people trying to decide a case.
Yeah. And the beauty of this show and what we do now is that we're not in a courtroom in front of a jury. And so we can tell you that
that's right.
Insurance is generally always involved most of the time. If the case is made it that far in front of a jury and inside of a courtroom and ready to be tried, it's usually because there is insurance that is, of course, protecting or, in the shoes of the defendant. And usually the lawyers that are there defending the case are being employed by that carrier.
Right.
And so that is something that I certainly keenly can appreciate it when you see a defendant who you want to know, do they have the means? Are they capable? And they're a little older or they're frail. And it's like, oh my goodness, I can't possibly, award a big verdict against that individual who, probably doesn't have any way to pay it.
Mm-hmm.
There's usually insurance folks. So that is something that we can say and share that you normally would never know and would not be able to know in an actual setting if you get picked for a jury.
Right. Yeah. I mean, if you hadn't had experience going through the process yourself or knowing somebody, you really wouldn't have any reason to think about it. But as a practical matter, it's would not be possible to pursue cases. There are a few circumstances where a case might be pursued where there wasn't insurance, but it's extremely rare because as a practical matter, it doesn't make economic sense.
Right, exactly right. And economically, you're right. That person would have to have some pretty tremendous assets in order to pursue that because of the costs that go into trying, cases. So but that was good. That was definitely an insightful memory, and I certainly will keep that in mind as well as I try more cases in my career. So good. Thank you so much for sharing that memory. As you know, again, if you are a client of ours, past or present, we certainly appreciate you. As we continue to celebrate our 70th anniversary, we love to share the memories with you all. And so that's why I do this, because it is something that I'm extremely proud of as a partner at the firm. And also just because we know that our clients are our biggest supporters. And sometimes that's the best compliment that we can receive is referrals back from our old clients, and they've kept us in business for all these years. So that's why we celebrate. But that being said, we've got a great show, folks, in front of us tonight. We're going to talk about some local cases here in Florida, and even more local in the Clearwater area where we're broadcasting from today. Various things that have happened in the news from the personal injury perspective we'll dive into. And then, of course, if time permits, we may get into a couple of those Google questions that Lori and I were talking about a few weeks back, maybe even longer, that we didn't get to the last show. So we'll see if we have time for that at the end. But let's talk about the biggest news article that I could find that made not only local news, but national news. And I was telling Lori, even off the air, that I think it even made TMZ, which was surprising to me because I'm like, okay, well, that's a celebrity news type outlet. Right. So I was shocked that it even made it to TMZ. But maybe it was a slow news day for TMZ, but it has turned into a viral moment, unfortunately, for this charter boat captain. So here's the article. Essentially, I'm sure a lot of our listeners may have seen the video, but it was footage that was posted by a 22-year-old man. He entitled the video, "A charter captain jumps on my boat and tries to fight me for no reason." And so if you saw the video, it was basically an altercation and arguing and going back and forth regarding an incident that I guess had happened earlier that morning of a speeding boat, and something, transpired. And then later on, these two individuals, I guess, encounter each other once again, and it turns into this screaming match. And then the charter captain apparently jumps on the boat of this younger guy and kind of threatens him. And so all of this is captured on camera. I think the fisherman is wearing some sort of GoPro type camera of some kind that allowed the whole thing to kind of be captured, and he posted it. So this news article basically gets into that and talks about, unfortunately, the owner, the charter boat captain is the owner of Tarpon Coast Fishing Charters, and ultimately he was arrested. And the charges that he was arrested for were burglary with assault or battery, and then they're obviously following that investigation further. And I was a bit surprised. Obviously, I haven't studied criminal law in quite some time, but I guess the entering of the boat might be the burglary component.
Yes, I had to refresh my memory on this too, but you can commit a burglary of a conveyance, and a boat would be included in that.
Got it. Okay. And so obviously, without giving all the sordid details, it was basically a lot of expletives and screaming, going back and forth, an argument of some kind. He ends up entering onto the other man's boat. The young guy is obviously quite fearful and afraid that he's going to cause him some sort of physical harm. And he's apologetic. I'm sorry. And, kind of trying to get the guy off of his boat. The guy's accusing him of not having his lights on earlier that morning or something like that. Of course, he denies that was even him. He just says that he was present, but that wasn't him. I don't know the full details of it, but it has now resulted in the arrest of the charter boat captain. And apparently it has had a very negative toll on him, his business, and his life. Now that this has occurred, it's pretty much his reputation has taken quite the hit. He does have an attorney who's basically said, please stop harassing my client. No one should really have to go through what he's going through. He did mention that he is a decorated veteran who has served in Afghanistan and suffered a traumatic brain injury during combat. And so he apparently is suffering from PTSD, and that could maybe account for some of the outbursts that he presented. So how does this play into personal injury? So I was thinking, and I thought about, this is kind of like a boat rage type of an incident. Sure. You don't really see it as often, but as road rage is certainly a thing, and car accidents and things happen. But does it make it any different when it's on the water? If we have incidents, they talked about earlier, somebody was speeding, their lights weren't on. If some sort of collision had occurred, how are these incidents handled? Are you familiar with that at all? And then also the assault component. We'll kind of take that into two separate things here. So it's the boat liability, boat accidents. We can talk about that. And then assault. So I don't think he was physically hit, the young man that was 22 years old. I don't think that there was actually a physical touching, but clearly he was quite upset and fearful. Is that enough to have some sort of a civil claim when there's no physical touching of his body?
So the criminal base, so the idea of the burglary, which you were kind of alluding to, you wouldn't really think about this but burglary is entering into a conveyance in this situation with the intention of committing an offense. So for that charge to be successful criminally, they're going to have to be able to show beyond a reasonable doubt that he was intending to assault this fellow. Now, of course, we live in the world, which I guess is maybe why TMZ picked up on it. It was pretty exciting footage.
It was,
outrageous, really, obviously,
very much so.
So we see what happened. But so I think you could, the young man was reportedly very afraid, and kind of understandably so, at least from what we could see. So there could be a civil action related to that. It would be in the nature of being, because an assault is actually threatening somebody with the apparent ability to act upon it. And actually, some of the background of the gentleman, would probably support a reasonable fear, because he was apparently relatively large. He had physical capabilities.
I think he even yelled that I'm a combat Marine or something like that. And I think he was like a ranger at some point, so he was, so I mean, there's all of this that would give some basis for that. Having said that, though, there would be other implications for damages in the personal injury context, because it doesn't appear that the young man was in any way physically harmed. So most likely, that would be a little bit hard of a claim, unless he had some, he would probably have a great deal of difficulty showing actual personal injury damages coming from that. The criminal case is a little different situation. I mean, that's a situation where the prosecutor on those facts, has a fairly strong case, it would appear. I have to agree with you. I think the difficulty with the injury side is going to be the damages, the physical impact. I don't know if I could be thinking of negligent infliction of emotional distress, but there's an impact rule with one of these. And so it's like, well, if he wasn't physically injured, and we don't know now if there's been any
touching, even. If there was no physical contact, then it could run afoul of that particular rule that many times you have to sustain some sort of physical impact to claim emotional damages, which is probably what would be at issue here for the young man.
And I did a little digging just to get a little bit of information on boating accidents, because obviously we are in Florida. I mean, we have beautiful weather, water. We sometimes forget that we live in the place where people vacation and consider it paradise, and we sometimes take it a bit for granted. But boating enthusiasts obviously come here, and this is just a part of the nature where we are here in the Tampa Bay area. And I didn't necessarily appreciate the number of boating accidents that do occur in our area. So I just looked it up a little bit. And it looks like statistically, we are the state with the highest ranks among the nation for registered boats and boating accidents. Just last year, it was about 836 boating accidents, resulting in 79 fatalities.
Oh, wow.
And 420 injuries. So that's quite significant. That's coming from the Florida Fish and Wildlife Conservation Commission. And apparently under Florida law, anytime there is a boating accident resulting in injury, death, or significant property damage, it must be reported to the Florida Fish and Wildlife Commission. I wasn't aware of that either. But I would imagine most of these cases are handled similarly as a car accident. You have to document evidence, take photos, seek medical treatment, and then the personal injury attorney is, our job is to investigate, and to find the coverages. Sometimes there's boating. A lot of times there's boat insurance, but sometimes even homeowners insurance may cover things. And so those are the things that we as the personal injury attorneys will investigate and look into. But those are things that just because you have an accident on the water doesn't mean that there isn't liability, or that they can't be pursued, or that claims can't be made. There is usually insurance that can be, pursued. And so that's something that I just want to look at to try to see the significant number of it, because, we do a lot of auto, but you don't always see boating accidents. And so I was curious, as I'm wondering that people just don't pursue them as often. But it is quite a number of them that occur.
That's
in the
a
state.
surprising statistic, really.
Yeah.
I mean, in a way, it's not, because I would have guessed we'd have a lot of boating.
And they're always
incidents.
they're usually traveling at high rates of speed on the water.
So I imagine, one thing I did have did not involve personal injuries, fortunately, but it was a friend of mine who was kind of up in age, and it's surprising that there's fairly limited requirements for being certifying that you are actually competent to handle the boat. As I discovered with my friend's situation, I was really a little bit surprised at that. And I would think probably anybody on the water would just know it as a matter of common sense that you need to be careful, because there could be, and there in fact are, widely varying capabilities and experience levels out there.
Very much so.
I mean, they pretty much, all you have to really do is apparently take like a boating education class or something, but it's not much.
Wow.
So now a person in the situation, obviously the gentleman that was the charter captain, has probably some more obligations, and he may well
that come along with him being a charter captain.
But for just recreational boating, it's the kind of thing that one has absolute responsibility. I mean, obviously, if you have an incident with your boat, in fact, probably the bigger issue would be insurance, and there is insurance similar to the personal injury protection insurance for auto cases. If you get it, it's not mandatory like it is in an automobile setting, and liability coverage. And like you mentioned, there may be some coverage under homeowners policies, depending on what the situation is.
Depending on how they're worded, and that's something that obviously can be investigated to see if there's exclusions or policy language that would qualify or not qualify a boating accident.
Right. And there definitely is that requirement. I know from my friend's incident that if you have a property damage of $2,000 or more, then you are required to report that. And of course, injury of any significance has to be reported to the Fish and Wildlife Commission.
That was something that I learned just today when I was researching that. So very, very interesting. So obviously, as we approach the warm weather summer months, as we're now in spring, although it was a little cooler this morning.
Yes, it was.
For a spring morning, it was actually a little cooler than I expected.
The rain cooled it down.
For all intents and purposes, we're, I'm sure, about to get very, very warm and very true to Florida weather here soon. That means more boating. That means, jet skis and all kinds of recreational water activities. And if those things, result in injuries, I think it's always important to consult with an attorney about
Absolutely.
it. Just to know what your rights are and how to properly preserve the evidence and properly report as you are required to under the law that we now know. And of course, can certainly review the facts and discuss, injuries and making sure that you're properly seeing, medical and documenting your injuries that way. But with that being said, I think it's a great time to take a short break before we get into some of these other more local news articles. They're right here in Clearwater. And we'll talk about those two Clearwater accidents that resulted in injuries when we come back from this short break. And you'll be here with Lori Robinson and I, and we are FLA Law live on the radio. We will be back shortly.
This is the Tan Talk Radio Network.
After a car accident, there are many questions that you need answers to. Who pays for my car repairs? Who pays for the medical bills? What about my lost wages? And more. The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
Back from that short break with FLA Law live on the radio. Hopefully you've been tuned in since 5. We have been talking tonight about personal injury law, as we are the personal injury attorneys with Perenich, Caulfield, Avril Noyes. My name is Jacqueline Bryan. I'm here with my co-host, Lori Robinson. And so we started out, of course, talking a little bit about the kind of what I've called the boat rage, a viral incident that happened in Florida here recently, and it kind of made the national headlines. And so I wanted to talk about a couple other articles that I found in regards to recent accidents here locally. But of course, the lines are still open. So if you personally have a question or would like to comment on anything we're talking about, the number is 727-441-3000. Again, the call-in number is 727-441-3000. That's how you call in tonight and ask any questions you might have for Lori and I in regards to personal injury law or any of the topics that we're discussing tonight. If you have a topic that's unrelated, but it's legal, definitely feel free to give us a call. And we will certainly try to tackle that for you live on the air. If you are tuning in from Facebook, I saw a few viewers on our Facebook page. If you're watching and you have a question, you can certainly drop a comment right there in the comment section, and I'll be happy to read that out for you live over the air to get that question and discussion going as well. We certainly want to hear from you. And so if you think of anything as the show goes forward, feel free to give us a call. So the next article that I want to touch base with you is very, very local because it actually happened right near our office. It was a moped rider, unfortunately, who was seriously injured a couple weeks ago in Clearwater. And basically a moped rider was taken to the hospital with serious injuries after a crash that happened on Sunset Point and Belcher Road in Clearwater. According to the first responders, the Clearwater Police Department and the Clearwater Fire Rescue, who came out, said that it happened in the evening around 8:15 p.m. So lighting may have been a factor, but it involved a moped and another vehicle. The moped rider, unfortunately, did have life-threatening injuries and was transported to Bayfront Hospital in St. Pete. Unfortunately, the other driver did stay on the scene and was cooperating with the investigation. So with that being said, I want to talk about mopeds because a moped is somewhat different from a motorcycle. And it's not the same, of course, as a four-wheel automobile either. And I know generally speaking, when we're talking about Florida car accidents, the number one thing that usually always comes up is Florida PIP law, the no-fault law, the 14-day rule. Anytime we kind of meet with new clients talking about car accidents, this rule and this law comes up just automatically because it's such an important rule. I was actually discussing it with someone on the way here to the radio station, explaining to them why Florida no-fault PIP law is primary, because they didn't quite understand, well, why is my insurance coming into play here when I was hit by someone who was obviously at fault, and shouldn't we be pursuing them and their insurance? And so I had to explain, why the claim is made under your own policy. And it's even primary, even before your own health insurance. And your health insurance will also look for that to be exhausted before they will typically start paying the bills in full. And so with that being said, it doesn't always apply. And so you don't always get the benefit of that $10,000 in medical benefits. And it depends on the mode of transportation, the type of vehicle that you're in, right? And so that's why the moped, when I saw it was a moped accident that sadly resulted in sounds like very serious injuries right on the corner where our office is located. I want to talk to you about PIP. So Lori, what is your understanding in terms of mopeds, and do those qualify as motor vehicles under the PIP law?
They do not, so that the individual is not required to have PIP.
Right.
However, in that situation, if there's no other PIP policy in his household or her household, whatever, then they probably would be able to get PIP through the vehicle that actually caused, well, and of course, it's going to be an argument about what happened there, but the other vehicle involved in the accident. But the moped itself, and it's so difficult. I was driving, I don't know where I was coming one recently, and a moped is like literally right in the middle of my lane. And it's, and I'm,
you want to get around it.
Right. And it's because they're not, they don't obviously
go very
30
fast.
miles is the cap for them. Yeah. And they're supposed to be off to the side if they can. Yeah. But, so, but it's obviously if you're in an accident, it was going to be terrible, but there's nothing required of the moped operator.
Right.
And that's where PIP comes into play. I had a case recently where the client did not want to claim on their PIP because they'd had some prior accident history and they were concerned about the premiums going up.
Of course, absolutely.
Understandable, but
that was the exact conversation I was
having. Right? But it's the law is set up so that the no-fault system operates with that PIP insurance. So and it's a good benefit. Really, if you're in an accident, that's what it's for, basically. So,
right.
But the moped situation does end up creating some issues. Yeah. So probably the coverage could be claimed under the other driver's policy.
Right.
Yeah. But there'd be no availability at all for the moped driver pursuant, because people, I suppose you could get insurance, but people don't, and they're not required to.
Sure. And there's so many different scenarios where you may get it, you may not.
Right.
I'm thinking of mass transit buses like PSTA or a Greyhound bus or something like that. You likely would not qualify to be able to get the PIP while being a passenger on one of those vehicles. However, my understanding is if you're on a school bus, a child on a school bus can claim their PIP and use their PIP when they're on a school bus. There's so many different little nuances in the law. And
that's why we love the law,
that's
and research.
Right. And that got me thinking. And I tried to go back and find the case. It's been so many years now because it was literally, I had just started at the firm and there was a PIP suit that had been filed by J. Avril, and the PIP claim, I think, was getting ready to come up for pretrial or something like that. And so I was doing some research going to the hearing, and the defense had filed a summary judgment and said that the car, it wasn't a car. I'm going to explain to you what it was in a moment. But the apparatus that they were in was not a vehicle under the statute. And when I read it, I thought, wow, I don't think we're going to win this. So, and the reason why is because it was like, first, let me read the statute and tell you what the statute kind of says constitutes a motor vehicle. So under Florida's PIP law, a motor vehicle is defined as any self-propelled vehicle, including a motor vehicle, a combination that is not operated on rails or a guideway, excluding vehicles moved solely by human power, motorized wheelchairs, and electric bicycles. That's basically a general overview. This particular case, a person was pretty badly injured, and we were trying to fight for the PIP, but it was like this motorized crane that they were in, and it's like, if you could imagine kind of like this lift of some kind, like maybe construction workers use to raise the height so they can reach taller things. I think he might have been a tree trimmer, if I'm not mistaken. Right. And so it was connected to a vehicle, but it could be detached. So on this particular day,
oh my gosh,
it wasn't actually connected to the motor vehicle. It was on a standalone status, but it could be moved around. You could move it forward, backwards. It could drive on its own. But it wasn't a vehicle. And so I really had a hard time finding any precedent, but I pretty much went to Jay and I said, I don't think this is going to qualify for PIP. He's like, well, we're not going to go down there and lose. So if you don't think we're going to win that, then, I think we should go ahead and let it go. But it was very interesting.
That is a very interesting.
If it had been attached to the original vehicle, I think maybe we had an argument to get past summary judgment. But it was completely operating on its own by like a remote control type thing. And he was elevating it and descending it. And as he was in this, a car came by and hit the crane. But I thought, I don't think he's going to be able to get the PIP. I'm sorry. So
Very interesting question.
Yeah. And then there's other situations where, I've had a client who was in his front yard. He wasn't in his car, but he was removing something from his car at the time. So he was in very close proximity to the vehicle.
Mm-hmm.
And I think he was maybe taking a rug out of the vehicle when this car loses control, hits a speed bump in his neighborhood, careens into his yard and knocks him down. Fortunately, he was okay. He didn't have any life-threatening injuries. His house didn't come out as well. But he got PIP, even though he wasn't physically in the vehicle. So there's all kinds of various ways to look at the PIP issues and understand it. But
and some of them very fact specific.
Which, it's very, very fact specific.
Yeah.
So determining whether you qualify or don't qualify, depending on the kind of vehicle that you're in, obviously may need some legal analysis from an attorney to be able to help you with that. Every now and then we do handle PIP suits. I've done them over the lifetime of my career.
Oh, yes.
And a lot of times they're very much warranted because it's like you'll get a denial on something. It's like, come on, this is pretty clear that you should be paying the PIP on this kind of a case. So if you encounter PIP issues, you certainly give us a call. And even if it's something that we don't help with, we can always refer to someone that can. All right. Any other comments that you had on PIP as far as the moped goes? Hopefully that gentleman's okay. I didn't see any. I try to sometimes look to see if the articles are updated.
Yes, because of course that particular, we know our corner is just
very, very busy.
Very, very busy.
Yeah.
It would be less so at night, but maybe not that much,
I didn't see any update as to his condition, so I'm hoping that he's doing okay. But those kind of accidents, mopeds, motorcycles, scooters, even now with the electric scooters, the injuries can be so significant. You're not protected by, a big vehicle. And so the injuries that you sustain is direct impact to your body.
Right. And so, unlike the boating situation, where you are, you're so exposed in a motor vehicle, obviously, to significant injury. And obviously with the mopeds and of course, many people are using the electric bicycles now, which is a great thing, So it sort of puts us all on notice that if you're in that type of a bicycle or what have you, or a moped, you've got to be super careful because it's so easy for people to miss you. Yes. And likewise, just as, if you're the driver, you've got to be super careful and aware and anticipate, to the extent you can, mistakes that people may make.
Absolutely. You have to be defensive rider.
Yes.
My last point on the PIP issue that I want to point out, and it slipped my mind and it came back to me. So I'm glad you said that. No matter whether you think you qualify for PIP or not, whether you're on a moped, you're not really sure, whatever the circumstances, you should always treat within the first 14 days.
Yes.
Because even if there is a legal issue of some kind about the qualifications of whether or not you're entitled to PIP or whose PIP you may qualify under, you still want to preserve that right by treating within the first 14 days. Because if you don't, regardless of whether we can find the legal aspect that would allow you to be qualified for that coverage, if you didn't treat,
then you won't have the benefit of that coverage.
Yeah.
And that, that it's so easy to just wait it out thinking, it won't be so bad. And then, and 2 weeks isn't a long time, really.
It's not. It goes by very quickly. And I'm one to say that I would probably be that person who takes some over-the-counter medicine.
Right,
and,
hoping that it'll go away kind of thing.
Yeah.
So really, if you're in any kind of a significant accident at all, you just do need to be sure to get an evaluation with the doctor within the 2 week period so that you don't have an issue.
Absolutely, definitely. Now, this last article is a sad one. It's a short one, but it's a sad one. And it is, of course, very local with Clearwater High School. Unfortunately, about 2 months ago in February, a Clearwater High School student passed away due to a bike accident. Early one morning, I imagine that he was going to school. A Clearwater High School student did die after a bike crash in the area of Keene. It looks like it was Keene and Cleveland Street. Yeah. So apparently the student, as reported by the Clearwater Police Department, was a 16-year-old Clearwater High School student, and he was crossing at Keene Road and Cleveland Street against the red light when he was struck by a car. He was also taken to Bayfront Hospital and unfortunately did pass away as a result of his injuries the following day. And the reason why I brought up this article, not just because it is local here in Clearwater, but also because the article specifically mentioned that although he was in the crosswalk, that he was struck while crossing against the red light. And of course, that leads me to believe that he didn't necessarily have the right of way. And sometimes those kinds of things, I think for people, they may automatically assume, oh, poor thing, he doesn't have a case. And that may or may not mean that. The family of this individual could potentially have what's called a wrongful death claim against the automobile driver, depending on the circumstances. Sadly, the way we look at these cases has now drastically changed, though, in the state of Florida because of the change in our law, which surprisingly now it's been already 2 years.
2 years, right?
Can you believe it? So with that, Lori, how do we kind of approach a case like this where there's obviously been the most severe of injuries that can possibly be sustained, which is death, and we have circumstances where it seems the evidence might point to the fact that the bicyclist who died may have been somewhat at fault. How do you approach that now?
And that would often be the case. In any traffic accident, there can be aspects in which there's shared fault. That's kind of a common circumstance, really. Yeah, and normally, and in fact, a jury, if the case went to a jury trial, they would have to divide up what they thought the percentage of responsibility was in terms of what was the cause of the accident. The issue is always negligence. So prior to 2 years ago, that's what would occur. You'd make your case for negligence. And in this case, one would always wonder as a lawyer investigating the case, could the driver, even if the bicyclist should have stopped and didn't have the right of way, should the driver have seen the crossing and been able to avoid the accident?
Right.
And so it would suggest the potential for some negligence there. So
it sounds like he was in the crosswalk. And then we have maybe lighting is a factor. February at 6:30 in the morning. It's a little darker at that time before daylight. Before the daylight saving change,
so it would be dark, but the thing that's happened makes it much harder. But it's still, absolutely there would be a case because that argument just presents itself on those facts. And normally we would expect there to be some division of responsibility there.
Yes.
It becomes an arguable fact, basically only decided by a jury ultimately, potentially, how you divide up those percentages. What happened 2 years ago is that now if a jury were to decide that the person injured was more than 50% at fault, in that situation, the law now bars any recovery.
Exactly.
Yeah.
That is the major change. Because prior to that, and we could I remember Brian sharing a verdict with me. I can't remember how long ago this case was, but he was telling me about a case where an older gentleman was his plaintiff, and he had somehow gotten into, and I may
the oil. Was this the oil change?
Yes,
and he fell into
it. And wasn't it like 90%? On his claim?
I was something like 90% was assigned to him, but he suffered very significant damages, and the jury made a very substantial award. And even that 10%,
that 10% was still, substantial.
Was a substantial.
But now under this new law,
I would just say
there would be no recovery whatsoever. With the 90% comparative fault being on the plaintiff. Right?
And, there can be arguments policy-wise about what is fair. Certainly most of my legal career has been you would divide it up as people saw the responsibilities. And
exactly.
I think the more – and that seems so that seems to be a fair approach. But these are always things subject to argument and, frankly, the jury that hears it.
Sure.
Because we never know who's even going to be on that jury till you're doing that. So you could be in an accident in which everyone said, oh, your fault. And a lot of times people are very hard on themselves and consider themselves to be at fault because somehow they didn't avoid something that they feel that they perhaps could have. So it's not something you should evaluate for yourself, because this is something that it would be the rare case in which anyone would be able to say, I have no idea what a jury would decide on the facts, just as we know them from the newspaper. I mean, there might be something else, but based off of that.
There could be a lot more to the story than we know at this present time. And that's what it really comes down to, the facts of the case and how the jury would view it, because ultimately that decision isn't for us or for the defense lawyers or for the insurance adjusters to make. That's a jury question.
It is a jury question. And, most cases do resolve without going all the way to a jury trial. Mm-hmm. Usually a settlement is reached based on both parties, the defense and the plaintiff, looking at their risk, because no one really knows what the jury is going to decide. Right. But things like that, the law basically puts that in a sense in the community. So the jury is selected for the case. If the parties cannot come to some sort of resolution, it's the jury's responsibility to make a resolution.
Right. And I think what we may see now with the change of the law, with the pure comparative, is that one of two things. You may see insurance carriers who are now emboldened to the sense that, normally, a case like this, a wrongful death, a bicyclist, then they don't necessarily want to take the risk, of which are such tremendous damages. The likelihood of a very, very large jury verdict is still high, even if there is a liability dispute, right? Just like you talked about with Brian's case, where he was 90% at fault, but the damages were so big. So under the old law, I think that the likelihood of still having some sort of early resolution was more likely. Now, under the new law, I think what you could see is it takes more time to get to that resolution, because now the law is somewhat more favorable to the defense argument, or they raise these defenses about the comparative fault and the fact that there's no recovery if it's greater than 50%. So that means more cases will likely have to be tried or have to get very close to trial before they would resolve. And an alternative, they might have resolved a lot sooner under the old law. And then the other theory, and I don't know how true it is, and I think it's probably too soon to tell, but I think there's data from other states who've obviously had laws like this well before Florida did. Some people seem to suggest, if in fact the jury knows that there won't be a recovery if they apportion the fault greater than 50%, then they're less likely to do it. And there's been some legal literature that I've read that says that juries will tend to not apportion the fault greater than 50% when they know that that's going to result.
Now, I wonder, I haven't actually had this question come up because I doubt that the jury is told.
Right. And that's the issue is can you get that on the verdict form? And how will the verdict form read? Will it say if you find plaintiff more than 50% liable, stop here, there's no further recovery or whatever, I don't know, it depends on how.
Sign them. Yeah, that's interesting, actually.
So if it's written that way, then
I
they
haven't
may
tried a
pick up
case
on
under that new rule yet.
Exactly.
But
that's the issue.
And that will be a very, regardless of how it's supposed to, how a court would rule the verdict form should be, it will be the subject of appeal.
It will be. It will be. So with that being said, don't ever try to self-evaluate comparative fault in trying to determine liability. Leave that into the hands of the skilled and qualified attorneys at Perenich, Caulfield, Avril Noyes, you've been listening to tonight on FLA Law, live on the radio. Lori, it's been a pleasure. Thank you for joining me as my co-host.
Always enjoyable.
Of course, our listeners, you should tune in every Tuesday at 5:00. We'll be right back here with more legal discussions, more opportunity for you to call in next Tuesday at 5 here at FLA Law live on the radio. We'll see you next Tuesday.
WTAN, Clearwater,
FM 106.1,
WDCF, Dade City,
FM 102.3.
Listen.